directly appointed as Judge of Civil City and Sessions Court by invitation. He was the first advocate to adopt computer technology in his legal practice as early as in 1985 in his computerized personal office on an LAN network. He has been he has been pivotal in developing the e-court system as he was in charge of the e-commerce committee of the Supreme Court, looking after computerization of court through India under the e-court project. As judge of the High Court of Gujarat, he dealt with almost all subjects and delivered approximately 19,832 judgments in 1,260 days. We express our sincere gratitude to Sir for accepting our invitation and taking out the time to judge Vakalat. Before commencing the competition, I would like to share the rules again. Each team will be given 20 minutes to plead their case. The teams are required to keep video on at all times and turn their mics off when the other speaker is speaking. Our esteemed judge will pose questions after the presentation of pleadings. The marking criteria for the final round is as follows: structure of legal arguments, knowledge and application of law, presentation, speaking skills, and courtroom etiquettes, preparation, persuasiveness, and advocacy. And the last, responsiveness to questions. The timer will be visible on the screen at all times. The court master will message in the chat box after completion of 10 minutes, 15 minutes, 19 minutes, and 20 minutes. Without further ado, we will now like to initiate the final round of Vakalat. May the best team wins, and we wish all the best to all the teams.
The court is in session. The appellant may begin with the court proceeding as the court may deem fit.
Counsel seeks permission to start the case.
Yes, you can start.
Much obliged, sir. My lord, we are representing the appellants. This is the first appeal filed against judgment decree dated 23rd January 2020, passed by learned Sessions Judge, whereby appellants were wrongly convicted. The appellants named Mr. Marks and Mr. Angels were arraigned as accused number 1 and accused number 2 in case in the file of Sessions Judge for commission of alleged offences punishable under section 120B, 124A, 153A, read with section 34 of IPC. My lord, the CAI, Central Agency of Investigation, on 4th October 2019, raided and investigated the headquarters of RPM party, whereby without a search and seizure warrant, they arrested 5 persons affiliated to RPM and trade unions, as well as seized computers and devices without following proper procedure mentioned by law. That the charges under section 120B, 124A, and 153A, read with section 34 of IPC, came to be framed against the appellants who pleaded not guilty and claimed to be tried. Section 120B deals with punishment of criminal conspiracy, stating that whoever is a party to a criminal conspiracy to commit an offense be punished in the same manner as if he had abetted such offense. But this isn't relevant as there was no criminal conspiracy. Section 124A deals with sedition. Explanation 2 of the section states that comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. In the case, there was mere intention to alter the laws which government came up with voicing their opinion and portraying private criticism for maintaining harmony in the society. Section 153A deals with promoting enmity between different groups on ground of religion, race, etc., and doing act prejudicial to maintenance of harmony. It refers to organizing such activity which intends participants to use or be trained to use criminal force or violence against different groups in community. There is not even a single stance where appellants are seen with intention to excite violence. The learned session judge passed a judgment wrongly convicting the appellants, whereas acquitting other 3 persons named Stalling, Zizek, and Kakmo for offences under the same charges. Hence, appellants has approached the Honourable Court. Your Lordship, Counsel seeks permission to call upon the co-counsel.
Yes, you can call. His
Appellant
mic,
2, you are on mute.
his mic is off. Yeah, now it's okay. No, yes, still his voice is not.
We can't hear you, Appellant 2.
Oh, he has been disconnected. Appellant 1 has prepared only this much thing.
He will join.
He's just trying to
Appellant
rejoin.
1,
And one.
your
Am I audible?
Yeah, yes.
Thank you, Your Lordship. Your Lordship, the council seeks permission to continue.
Continue. Yes, continue.
Your Lordship, the council will now state the grounds on which the appeal stands. That the impugned judgment passed by the learned special court is bad in law and hence deserves to be set aside. Your Lordship, ground number 1 is as the learned special court, without considering and appreciating the most material and legal issue points specifically raised by the counsel of the defendant, appellant, that the alleged evidence, which neither admissible in evidence nor they have any presumption of truth, and moreover the evidences that the prosecution has filed are in question or due to their authenticity and genuineness. Your Lordship, ground number 2, the appellant and 3 other people were accused for the same charges in the same trial in front of a learned special court. But the 3 other people, namely Stalin, Zizek, and Katmo, were acquitted. This puts a dent in the story of the prosecution, my lord. The learned special court has also not provided with any specific finding that why these 3 people were acquitted and why appellant was accused. Your Lordship, this very fact shows that the incompetency of the prosecution to satisfy the learned special court with any well-settled evidence. This is to be emphasized that there was no any well-settled evidence, and the learned special court passed the judgment without being sure beyond the reasonable doubt, which is the most basic element of Indian criminal jurisprudence. Your Lordship, ground number 3, that the prosecution did not follow any procedure related to the CRPC as in section 165 subsection 4 in read with section 5 states that the police is required to search the alleged area in the presence of possessor of that alleged area and is required to prepare a list of all things seized in the course of such search and of all of the places in which they are respectively found, and it shall be prepared by such officer or other person and signed by such witness, but without due process of law. Your Lordship, the prosecution went too far and they seized the documents without search warrant and they have not made any list of the record items. Your Lordship, this was done intentionally by the prosecution so that the prosecution can plant fabricated evidences and temper the existing evidences, which is totally illegal, unfair, unjust, improper, and against the law. And this is with this patent illegality, the learned special court, wrongly relying on these evidences, passed the judgment and did not consider this point, and this caused a grave miscarriage. That the whole case, Your Lordship, point number 4, that the whole case of prosecution is based and supported by the emails and the WhatsApp chats retrieved from the devices seized by the CIA from the head office of RPM, for which no certificate under Section 65B of Evidence Act 1872 was obtained. Section 65B certificate is procedural and mandatory step in Evidence Act, which was overlooked by the prosecution. Your Lordship, it is clearly evident that the electronic records produced before the court will be considered as documental evidence. For such an electronic record to be admissible, it must not be tampered with or modified. For this, Section 65A of Indian Evidence Act 1872 states that the contents of an electronic record may be provided in accordance with the requirements specified in Section 65B. As a matter of practice over the last few years, we have observed that WhatsApp chats or communication happened over and social media for that case are submitted in the form of printouts, which is a secondary evidence, Your Lordship, in the form of printouts of actual chats. This practice clearly states WhatsApp chats out of the scope of Section 62, and they cannot be considered as primary evidence. Your Lordship, the Council would request you to refer to the page number 8 of the appeal and to refer the case titled Arjun Panditrao Kotkar versus Kailash Kushan Rao, which was reported in 2020 RCS Civil 256. And in the para number 59, it is stated that the Supreme Court has stated that we may reiterate, therefore, that the certificate required under Section 65B4 is a condition precedent to the admissibility of evidence by way of electronic record as correctly held in Anwar and correctly clarified by in Safi Mohammed. Oral evidence in the place of such certificate cannot possibly suffice on Section 65. Subsection 4 is a mandatory requirement. They have mentioned, Your Lordship, that it is a mandatory requirement of the law. Indeed, the hallowed principle in Taylor versus Taylor, which has been followed in number of the judgment of this court, can also be applied. Section 65B, subsection 4 of the Evidence Act clearly states that my lord, I want to emphasize, clearly states that the secondary evidence is admissible only if plead in a manner stated and not otherwise. To hold otherwise would render section 65B 4 years. Your Lordship, point number 4, that the evidence on record of prosecution does not hold any stance in law, as from their discovery to admission in the court of law before this special court, prosecution has not followed a single rule or procedure set by the legislature of the country. They have made the rules and procedure as a mockery. Your Honor, Your Lordship, the Council will refer to ground number 5. The Central Agency of Information in their press release clearly mentioned that they raided they made raid in the RPM office on the basis that they received intelligence in which it was mentioned that the RPM officials were involved in foreign funding from foreign elements to destabilize the government of Mordor. But the prosecution has failed to prove and to give not even single evidence, not even a single witness that shows that the appellants were involved in any foreign elements, and they have attempted to destabilize the government. And the basic foundation of their case is not been proved. Your Lordship, neither in the FIR nor in the charge sheet, the prosecution has or the police has not mentioned the active role of the appellant. And this is very important to mention the active role. Your Lordship, the appellants are accused of Section 124A, which states that they have made a sedition, which is a sedition. So the council will state ground number 6 that states that Section 124A, read with explanation 1 and explanation 2, clearly states that a person can criticize the work of government to obtain alteration. Your Lordship, to alteration by lawful means, and a lawful protest is one of the many lawful means. The only reason the appellant have given the statement was the alteration of the labor laws that were enacted unanimously by the government without much discussion in the parliament, and it was against the feelings of the people and the common people, not the political people. Your Lordship, the common people were against this, and this has been recently observed by the Supreme Court recently that by rejecting a PIL against Farooq Abdullah. Farooq Abdullah gave a statement related Article 370, and the Supreme Court rejected that PIL and observed that not seditious to disagree with government. Political parties can disagree with government. And there is a landmark judgment named Kedarnath Singh versus State of Punjab, reported AIR 1962 SC 955. In that also it is mentioned that the provisions of the section read as whole, along with its explanation, make it reasonably clear that the section aimed at rendering penal only such activities as would be intended or have a tendency to create disorder or disturbance of public or peace by resort to violence. But there was no violence, there is no proof, and there is no instance where the respondent can show there was a violence due to the appellant's speech or due to any act of the appellant. And it is also mentioned that, as already pointed out, the explanation appended to the main body of the section make it clear that criticism of public measures or comments on the government action, however strongly worded, would be within the reasonable limits and would be consistent with the fundamental right of freedom of speech and expression. But the government couldn't take this freedom of expression in a good way, and they planned a criminal case against the appellant in a political fiction. This is the council's sixth ground, that this is a clear case of political fiction between the ruling party and the opposition, and it is a measure taken by the ruling party to silence the voice of the common people of the country and of the politically active opposition, and is very against the principle of constitution and hampers the working of a democratic republic country. And this has been affirmed in the Kedarnath judgment. And this has been affirmed by the Supreme Court in coal scam case, that the central agencies like CBI and other agencies are the puppets and the cage parrot of the central government, and they work accordingly central government in a wrong way. This needs to be considered. Your Lord, another ground is that there was no mens rea. Mens rea is the basic element of a crime, and without which no act can be called crime, no accused can be held guilty without criminal intention. And the prosecution has failed to prove that there was any mens rea, and this has been affirmed in Director of Enforcement versus MCTM Corporation Private Limited, which was reported in AIR 1996 SC 1100. That mens rea is a state of mind under the criminal law. Mens rea is considered as the guilty intention, and unless it is found that the accused had the guilty intention to commit the crime, he cannot be guilty of committing the crime. Your Lordship, the appellant or the counsel also want to state that the prosecution has failed to prove any clear motive of personal aim. There was no clear motive. There was no motive on the hand of appellant. There was just a genuine concern for the common people, and they have no specific finding regarding this, and are being accused only on the whims and fancies of the government of model, and they are being accused only on the basis of mere conjectures and surmises, because there are no proof, and the evidence they have collected are only without the procedure and are illegal, and they are set to be aside. Your Lord, the council also want to mention that the common intention animating the accused leading to the doing of criminal act in furtherance of such intention. It must be shown that criminal act complained against was by one of the accused person to the furtherance of the common intention of all. But there was no common intention, since there were 5 accused in the main case, but only 2 were convicted and 3 were acquitted. So this puts a dent in the story of the accused. And relating to the section 120A and 120B, which deals with criminal conspiracy, I would the council would like to refer to the judgment Ajay Agarwal versus Union of India, which was reported AIR 1993 SC 1637, which states that the offense is complete as soon as there is meeting of minds and unity of purpose between the conspirators to do that illegal act or legal act by illegal means. And your Lordship, the council and the appellant request the honorable court to come up with FSL report of the evidence which have been provided by the prosecution, since there is a doubt with the genuineness and the admissibility of it. So we request that the prosecution come with the 65B certificate and FSL report. Now, your Lordship, the council would seek permission to call upon the co-counsel to the dance.
Yes, permitted. Yes.
My lord, counsel seeks permission to continue.
Yeah, continue. Yes, continue.
The respondents pointed out that the appeal itself is inadmissible, not maintainable, and the Honorable Court does not have jurisdiction to entertain the criminal appeal. It is to bring into everybody's notice that the above arguments are irrelevant and Section 372 and 372 Clause 2 of CRPC has been misunderstood by the opposition party. The appeal is a matter of right and can be against any order, screen, conviction, or judgment, irrespective of the sentence. The interpretation of the section is wrongly understood, and in fact, the case they mentioned is also misunderstood. Secondly, referring to page number 10 of pleadings of the respondent, as they mentioned in point number 26, the intention to cause disorder or incite people to violence is sine qua non of the offense under section 153A IPC, and the prosecution has to prove the existence of mens rea in order to succeed. This clearly means that violence is the essential element here, and no instance of violence is observed. The mere intention to alter the laws is there. The people who were directly affected by the amendments made by the government of Modor just voiced their opinion in the form of a peaceful protest. There is no existence of mens rea for inciting violence. My lord, referring to Milan 23C 347, it should be noted that the duty of court in a criminal appeal is not similar to that of a civil appeal. The standpoint is not whether the decision is wrong, but whether the conviction is right. If there is any doubt about it, order should be set aside. The appellant therefore prays that the appeal be admitted, that the records and proceedings be called for, that this honorable court may be pleased to quash and set aside the impugned judgment dated 23 January 2020, passed in Sessions case by the learned Sessions judge, and the appellant be acquitted by allowing the present appeal. Such other and further reliefs as this honorable court deems fit in the interest of justice. Thank you.
So you have, both of you have completed your submissions. Appellants have completed.
Yes, your lordship. This,
Okay.
this is the final pleading of the appellant.
Okay. So now respondent wants to continue. Yes.
Sir, if you want to ask questions right now, you may.
I think let the questions be at the end, because otherwise it would give a hint to other side. Let me
Sure,
query
sir,
them.
sure.
Yeah, let me query them after
Sure,
listening other side. Otherwise,
Yes, sir. So the respondents may start
yeah,
now, please.
I have noted something. We'll query them just to guide them, but at the end of the argument.
Sure, sir.
The counsel is appearing on behalf of the respondent. Counsel would like to take your permission to address you as your lordship.
Yes, permitted. Yes, start it.
Much obliged. As the facts have already been dealt with by the appellant and in the written statement, and due to the limitation in time, the counsel would seek your permission to skip the facts and would straight away start with the preliminary objections.
Yes, permitted.
Much obliged, your lordship. We would like to raise the preliminary objections as against the appeal. At the outset, the first objection is that the absence of culmination of proceedings before the trial court, this criminal appeal will not be maintainable in accordance with the provisions of section 374, subclause 2 of CRPC. Secondly, that the evidence obtained without a search warrant is admissible in the current case. Thirdly, the emails and WhatsApp chats found in the seized mobile phones and computers is admissible without a certificate under section 65B of the Evidence Act. And lastly, that the prosecution has adequately established the charges against the appellants under section 124A and 153A before the trial court. I will be dealing with the first two issues, while my co-counsel will be dealing with the third and the fourth issue. The first issue being dealt with is whether this criminal appeal is permitted in accordance with the provisions of Section 374 of the Code of Criminal Procedure. The trial court on 23rd January 2020 acquitted the other three accused while convicting Mr. Marks and Mr. Angelis, the two appellants here, under Section 124A and 153A, and the matter was listed for hearing on sentencing. In the interim period, even before the sentence was passed, this appeal was filed under Section 372 and 374 subclause 2. It is submitted that after the bare reading of Section 374 subclause 2, it is clear that an appeal under Section 374 subclause 2 lies only in a situation when the trial court has given a judgment and order of conviction in which a sentence of imprisonment for more than 7 years has been passed either against the appellant or against any other person convicted at the same trial. In the present case, though the conclusion saw the conviction of the appellant under Section 124A and 153A, no sentence was actually passed by the trial court, and moreover, it is submitted that for both of these sections, the minimum prescribed punishment is actually less than 7 years, and without actually receiving a sentence greater than 7 years, an appeal cannot be filed in this case. And it is further submitted that the right to appeal is actually a creation of the statute, and unless the statute confers the right to appeal on an aggrieved person, appeal cannot be presented to and entertained by any court, and therefore the provision needs to be applied in a strict sense, which was also held by the Honorable Karnataka High Court in the case of Jayanti Day versus State Assistant Drug Controller, which is available on page number 3 of the counter affidavit. It is therefore submitted that the very appeal filed under Section 374 subclause 2 of CRPC isn't maintainable. Coming to the second contention of the respondent, the second contention is that the evidence obtained without a search warrant will be admissible in this current case. It is submitted that when CAI received an intelligence report which pointed that RPM was colluding with foreign elements with an intention to destabilize the government of Modor, the CAI went forward and raided the head office of Red Party of Modor, RPM, which was situated in Lal Sheher, and they found incriminating evidence there. It is submitted that under Section 165 of CRPC, CAI had the authority to collect evidence even without a search warrant, provided that the piece of evidence was necessary for the purpose of an ongoing investigation, and which cannot be obtained later because of the delay. And in this situation, because the strikes were going on and the three cities were badly affected, therefore it was necessary to take the evidence without further delay so that there could be a stop on the same. Further, it is submitted that the procedure for arrest and seizure is provided under Section 100 of CRPC, but a mere deviation from this procedure does not vitiate the whole trial itself, as was contended by the appellants. And further, it was held by the Honorable Supreme Court in the case of State of Punjab versus Balbir Singh, which is available on page number 6 of the counter affidavit, that the non-compliance of these provisions, that is Section 100 and Section 165 of CRPC, would amount to an irregularity, and the effect of the same on the main case depends upon the facts and circumstances of each case. And in such a situation, the court has to consider whether any prejudice has been caused to the accused, and it has to also examine the evidence in respect of which in search of which of the fact that these provisions have been complied with, and further it needs to consider whether the weight of evidence is in any manner affected due to the non-compliance. In this present case, the trial court had actually called upon and examined the evidence, and which led to the search, and and therefore it is submitted that the search and seizure of evidence from the head office of RPM without actually getting a search warrant is merely an irregularity and does not vitiate the case of the prosecution altogether. Further, it is submitted that irrespective of the legality of the procedure through which evidence was obtained by CAI, it will be admissible. For the same, reliance was placed on the case of Puran Mal, etc., versus Director of Inspection, which stated that the test of admissibility actually lies in the relevancy of the material and not on how the material was obtained. It is further submitted that the evidence obtained without a search warrant will still be admissible because it is relevant to the ongoing case. Now, my co-counsel will deal with the other two issues. Thank you.
Yes, continue.
Your Lordship, the co-counsel seeks permission to continue with the rest of the issues.
Yeah, continue. Yes, continue.
The third issue is the admissibility of the emails and WhatsApp chats found in seized phones and computers without a certificate under Section 65 of the Evidence Act 1872. It is humbly submitted that the WhatsApp chats and emails recovered from the phones and the computers seized from the Red Party of Moda's office will be admissible even without a certificate under Section 65B of the Evidence Act. From a bare reading of the Section 65, it is understood that Section 65B is applicable only to secondary evidence. Placing the reliance on the case Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gorantyal, it has been clarified by the court that the certificate under Section 65B is not required when the primary evidence is presented in the court. It is submitted that in the present case, the respondent has procured the emails and the WhatsApp chats data from the phones and the computers seized from the office. Here, the phone and the WhatsApp and the computers were in the custody of the respondent, which were presented before the trial court, and the same can be presented before this court if the court would call upon the same. It can be presented as a primary evidence before this honorable court. The same was held in Vikram Singh versus State of Punjab, where audio tapes recorded as magnetic media were relied on without a certificate under Section 65B, and the court held that as they were primary evidence, they did not require a certificate under Section 65B. The need to comply with the certificate under Section 65B is done away with when the primary evidence can be brought before the court, as was done in the trial court by the respondents. Therefore, the respondent submits that WhatsApp chat and the emails will be admissible evidence even without a certificate under Section 65B of the Evidence Act. Now the fourth issue put forward is as to whether the prosecution have adequately established the charges under Section 124A and Section 153A of the Indian Penal Code. It is humbly submitted that the prosecution has adequately established the charges under Section 124A and Section 153A against the appellants. It is also submitted that the trial court has in the current case appreciated all the evidence placed before with careful consideration, and the guilt of the appellants was proved beyond the shadow of doubt. The trial court acquitted the other three accused of the case as the prosecution was able to prove without any doubt that the offenses under Section 124A and 153A against the appellants. Further, it is submitted that the onus of proof that the respondent was not able to establish the guilt of the appellants lies on the appellants themselves. So was held in the case of State of Karnataka versus Bhimappa, that the High Court allowed the appeal against the conviction in a murder case, acquitted all the accused person, probably influenced by the false accusations against some others, without appreciating the trial court's reasoning for conviction. The Supreme Court reappreciated the evidence and set aside the acquittal and restored the conviction of the accused. And hence, in the present case, it is submitted to the Honorable Court that the onus of proof lies with the appellants, and the evidence is, and the prosecution has adequately established the charges under Section 124A and 153A. It is further submitted that the appellant number 1 and appellant number 2 under Section 124A and 153A have purposely made instigating assertion in press conferences to stir animosity in the people against the government. The appellant number 1 had on 24th August 2019 made remarks in a press conference that no data has been put forward by this government. They have only given us empty words, and we all know where these words are coming from. The appellant number 2, in another press conference dated 12th September 2019, stated that I don't think this new government understands what security is. This government is incapable of deciding what is good for this country and its people. They are only trying to mislead us and to profit their industrialist friends. The appellants have, through these remarks, tried to sow hatred or contempt in the people towards the government. The appellant number 1 has made baseless false statements regarding the government not possessing the required data about the incompetence of the labor law. That statement made is false, as the Second National Commission on Labor 2002, appointed on 15th November 1999, found that the existing legislation on labor law were too complex and the provisions were provisions and the inconsistent definitions, and it recommended that the consideration of central labor laws into broader groups to improve the case of compliance and ensure uniformity in the labor laws. It is also submitted that in the present case, the attempt was made by the appellants to excite such a feeling through words and actions by the appellants when they expressed dissatisfaction at the functioning of the government and consecutively called out for a strike, nationwide strike against the labor laws passed by the government. The Honorable Court in Indra Das versus State of Assam laid down the ingredients for an act to be seditious, saying any words which can be either written or spoken, or signs which include placards or posters. Second, must bring hatred or contempt or dissatisfaction against the government, and third, must result in imminent violence or public disorder. Therefore, the prosecution has adequately established that the appellants have made speeches against the government, and they tried to bring hatred and contempt against the government in the people's mind, and have also called out for a nationwide strike which put 3 cities of the country of Modar into lockdown, which created public disorder. That it is also submitted that the prosecution has adequately established that the appellants by their statements have created disharmony and feelings of enmity among the people and of various groups and communities under the grounds of employment under section 153A of the IPC. The appellant number 2 in the press conference dated 12 September 2019 stated, and then they plan to bring about these draconian exploited laws with no regard for millions of our workers who make this great nation of Moda. They are only trying to mislead us and profit their industrialist friends. The above statement, the appellants aim to direct the people to think that through the new labor codes, the elected government is only looking after the industrialists and not for the workers of the country. Hence, trying to create a rift among various groups of people and communities on the basis of employment. It is also submitted that on 19 November 2019, the RPM party called a nationwide strike opposing the new labor laws, which instigated protests and put the whole and the three cities of the nation into a standstill due to this protest, and the army had to be called out by the government. The Allahabad High Court in Mohammad Khalid Hussain versus State through SHO stated that to ascertain whether an offence as defined under 153A of IPC has committed or not, the words either spoken or written or signs or by visible representation, and to come to a conclusion whether they have a tendency to promote attempts to promote on the grounds of religion, race, or place of birth or residence, language, caste, or community, any disharmony or feelings of enmity, hatred, or ill will between different religious, racial, language, or religion groups or caste or communities. And the same was also retraced in Balwant Singh and another versus State of Punjab, where the Honorable Court observed that the intention to cause disorder and incite people to violence is the sine qua non of the offense under 153A of IPC, and the prosecution has to prove the existence of mens rea in order to succeed. In the present case, the prosecution has established by way of leading cognate evidence on record that the appellants have through their speeches tried to create differences between or disharmony between various groups of people and communities and among regions by calling out a nationwide strike, which consists an offense under Section 153A of ITC. Hence, the prosecution has adequately proved that the appellants, who are the members of RPM, are party to the conspiracy committed under 153AB and 124A of IPC. And the mens rea was to create in the unrest in the country and have attempted to sow dissatisfaction against the government, leading to public tranquility and disharmony among the people, which has been done apparently for vested interests. It is also submitted that the speeches and the actions of the appellants cannot be claimed as a matter of right under Article 19 of the Constitution of India, as the same are amply covered under Article 19, Clause 2 as reasonable restrictions, which can be imposed by the state on the ground of public order. The Allahabad High Court in Ram Manohar Lohia and others versus State of UP observed that while on the one hand, the necessity for the right of freedom of speech and expression to assemble peacefully and without arms in a democracy is there, it cannot be denied that this right itself cannot be properly exercised by all without permitting a law which imposes reasonable restrictions in the interest of public order. No democracy can exist if public order is freely allowed to be disturbed by a section of the citizens. In the light of this case, the present matter, the actions of the appellants disturbs the peace and the public order and tranquility of the state. The speeches by the appellants were followed by their action of a nationwide strike, which intended to bring the entire country into a standstill, which could create a reasonable restriction on the public order under Article 19, Clause 2 of the Indian Constitution. That it is also submitted that the appellants have attempted to apply a theory, falsus in uno, falsus in omnibus, which stands for the part of the story is wrong, then the whole of the story stands wrong. But it is submitted on behalf of the respondent that has no application in the country of murder, but only in England. Hence, the acquittal of 3 accused by the learned Sessions Court does not hold the charges against the appellants in the present appeal wrong and does not lend the evidence produced to be false. Hence, in the light of the arguments made, it is humbly prayed that this criminal appeal be dismissed by this honorable court along with the exemplary cause.
Yes, you have completed.
Yes, sir.
Thank you. So both of you have completed in time, before 20 minutes.
Yes, sir.
Yeah. So now, whether Rajiv and Gaurav first would like to comment on something on that?
Yes, sir. Actually, a very good afternoon.
Good afternoon.
It was really nice, even though I was traveling today, but it was really nice hearing young children. I think they need to practice a little more because
exactly
in the courtrooms, you wouldn't be allowed to, render something as if you're reading something. So, because the honorable judges may not be that patient as my lords have been today.
So I was dozing sometime.
Yes, I could. In fact, we would have been happier if these students would have said something on their own, even if for 5 minutes. What I wanted both the sides to come up with was their own points and then frame it in their own language, say whatever you have to say, because it's all everything you have to say. And you're not supposed to write something down on a piece of paper and just read it over to the judge, because you're supposed to convey your point legally, and you're supposed to convey it in your own language. That's all. I think They're all in learning stage. Very good effort. They'll all learn. With this, I'll just conclude my part and hand over to my colleague.
Yeah, Gaurav, would you like to?
Sir, firstly, I would like to thank you all for being a part of this competition. And secondly, I'd like to just give a vote of thanks to all the participants also. I like to second the same thing that Rajiv sir said. It will have been more great if and more appreciable if all the participants would have prepared a little bit more, and but within the paucity of time they have tried to do their best. And so I like to apprise that my team, the appellants team, they are just the law students of the first year, and it's only 3 months they're into this law course, and in spite of that they have been able to put forward their points. And I also like to congratulate the respondents team. They have also been able to put across their points. And I like to admit to the fact, when I was pursuing my law, since mine was an evening course, I didn't had an opportunity to participate in the like a moot court competitions and all. But this is my first moot court competition that I have been a part of, though I'm part of as a mentor. So I tried my bit to guide my team, and they have been able to put across the points. And with this, I like to conclude it, and wishing you all the teams all the very best. And sir, thank you very much for a valuable time. I would like to close my comments here, sir.
Okay, thank you, Gaurav. So now all the participants, both the sides, appellant and respondents, you have heard the both guests, valuable comments by both the learned advocates. In fact, first of all, I would appreciate all of you for doing such a thing, because the first thing is, you have concluded your argument in given time, at least 1 minute less than given time. See, generally what happens, that courts are always busy with more work, and therefore time is practically now it's a more concern than anything else. So I'm happy that you have completed your arguments in a given time. So far as arguments are concerned, as Rahul has said, some more practice is required. Only reading is not material, that's fine. But at the same time, there is no other way. You have to read something from papers. But look to the court so that you can see that court is not, or at least court is listening to you. You must be careful. You must involve the court, the judge, to listen your arguments or to read what you are reading. So far as merits are concerned, the topic is very typical. So it would be a debatable views of a different person. So I will not discuss on merits of those topic sections and everything. But so far as your arguments are concerned, now I will raise questions to both of you one after another. Preferably first appellant. See, it's a simple error, but you have to be careful. In a criminal matter, appellant number 1, in a criminal matter, the judgment is a judgment, it is not a decree. I don't have your argument in my hand. So if you prepare a written argument, a judgment in criminal matter is not a decree. Decree is an operative order which is to be executed in a civil matter. In criminal matter, operative order is a sentence, conviction and sentence. But judgment is judgment. There is no difference of conviction or sentence in part of a judgment. This is just for your information. You have to be careful. Even if you say decree, it doesn't change your case, so don't bother. It doesn't affect your merits. Then when you have completed it in 18 minutes, it's fine. But you have not mentioned that what actually, none of you, both of you have not mentioned that what actually defamatory, not defamatory, but seductive or offending material. What is the real text in email which creates an offense or which results into commission of an offense? I tell you in a simple words, if I file a complaint of a murder, See, why I am saying murder? Because it is very easy to realize and understand. If I file a complaint of murder, if I am arguing about a murder, if there is no death or a dead body or a post-mortem note, then there is no murder. So when you are talking about any offense, the basic details of offense in a minimum words, at least in a minimum words, needs, because appellate judge is not a trial judge. The appellate judge has not seen the trial. He is simply reading the judgment and appeal, memo of appeal, and judgment by the trial court. So he doesn't realize that what is the offense unless you convince or explain that, see, this is stated as an offense, but it doesn't form an offense or it doesn't create an offense. So far as respondents are concerned, in such mock court is okay, but in generally in any kind of appeal, civil or criminal, counter affidavits are not there. So your affidavits in appeal is not material. Whatever you have to submit, it may be in the form of submissions or orally. Because when you say affidavit, you must realize that then you are bound to confirm whatever is stated in on oath. Either it is in trial court or before the trial court or in an appellate court. If you file an affidavit, something on an oath, then you can't go back. So sometimes arguments included in affidavit may create a problem, like when we are talking about 124 and 158. Many times in argument you have to say that lower court has failed or lower court has done this or that, or other side has done this or that. That may, because as a law student you must realize that what is what and how to submit something before the court. So this is just for your information. But now you have to realize that what is primary evidence? You have simply relied upon Evidence Act, Indian Evidence Act. But have you bothered to read out or refer the provisions of Information Technology Act and primary evidence in case of evidence which is only in digital form? Because in digital form, every evidence is primary evidence and every evidence is also similarly secondary evidence, because it can be easily transformed from one unit or one instrument to other instrument. So which is primary evidence and which is secondary evidence? This is what you have to explain to the court. For your understanding, I tell you, when you take printout of an email, then printout, because before the court you have to submit email. The judgment which you have refer, some Allahabad or Supreme Court judgment, if you recollect, there is an audio cassette which was played before the court. An original audio cassette, physical original audio cassette was played before the court through tape recorder. Then it is a primary evidence. Because that voice is there in that audio cassette only. It can be copied on other media, but initially it was on that tape recorder. So far as emails are concerned or any digital evidence is concerned, you must realize that digital evidence is practically in the form of 0 and 1s. It is not either in alphabet or not in a voice. If you take physical printout of that evidence from machine, that machine language is only in 0101 110 is a digital format. So when you take printout of an email, there is a facility in printing feature of all software and printers that email will be printed with a footnote, and in that footnote there would be a details that from where this printout is taken and what is the source of this email. Their IP address would be there, IP address of sender of the email. So when you are talking about digital evidence, means email, and when you say that it is proved before the court beyond reasonable doubt, you have to show these details to the court. This is a mock court, so we don't bother about it. Don't worry, I'm not finding fault with you. I'm not finding fault with you, but subject is such, you have chosen such a subject, and evidence only through email, I think it is better to explain to you, because somebody has read it. I am using computer since 85, so I know what is what. So this is not a nothing against you, not a comment against you, but it is for your understanding. Similarly, so far as merits of the case is concerned, unless those facts are there on paper or argued before the court, it is very difficult to decide that what is what, or whether conviction is proper or acquittal is proper. When both of you have said that 3 of them were acquitted, none of you have make it clear that why the 3 accused were acquitted. There is no evidence against them, or there is no involvement by them. What is the reason for that acquittal? Anyway, both the teams have done their best. Now probably we have to assign marks privately.
Yes, sir. Yes, sir. And if any questions that you would like to ask the teams, that also we can do right now.
Look, questions which they would not be enough. Questions are the factual details are such that there would be no much questions except these 2, that what is primary evidence, but they would not be able to explain it. I myself has raised the question and give the answers also.
Yes.
because asking them to answer it.
And my lords, I think those questions are the most tough questions even for the trial court lawyers to answer at the time of the trial.
Yeah, exactly.
Digital evidence is for the time being, the laws are very new, and this is a biggest challenge, in fact, for every trial court lawyer to prove it beyond the shadow of doubt. It is really difficult.
No, but now
we had an opportunity to prove a certain electronic account on this account that your lordship had just commented, that take a printout, and then it was only a professional expert from the IT sector who explained to us that what is the source, what is the time when it was created, and everything. But the question there what it leaves is, even if you take the printout, you will need an expert evidence to deal with the same, that this is the fact situation. So that is something which is quite daunting for the lawyers, and yes, my lords are right. It is IT Act is something which they I think they did not think about.
No, but who is managing this? Time is there. I can share you one judgment.
Yes, sir. Please go
ahead. See, we are in 2021, right?
Yes.
Before 21 years, in the year 2000, before 21 years, in the year 2000, I have delivered one judgment as a city civil and sessions judge. It was a civil suit where I have given a stay against encashing bank guarantee to one Indian company, Ahmedabad-based company, who are appearing or who are practicing before Supreme Court in civil side. Both of you will realize that otherwise there are judgments of Supreme Court that there can't be a stay against bank guarantee or a letter of credit, because it will stop the commercial transactions. But as there is a condition in almost such cases, there is a condition in that order also that in case of fraud, yes, you can stop bank guarantee or letter of credit.
Fraud vitiates everything.
Fraud vitiated everything. Now, this is interesting case. A Ahmedabad-based company has attended what you can say seminars or something at Singapore. It's a business fair. He attended there. They see the sample of cotton and give an order, place an order of a raw cotton to an American company. American company has said that this cotton is iron is not required. If clothes are made from this cotton, that clothes may not require frequent ironing. Wrinkle free. What we can say, wrinkle free cotton cloth.
Yes.
Indian company has placed an order Now you see, you will surprised to note it, in the year 2000, before 21 years, there was no paper or document about this transaction. Everything was only through email. From Ahmedabad, there is an email to Singapore, to American company. Now the transaction conditions of transaction was that goods is to be shipped from USA. It would be reached in Ahmedabad on a particular date. The bank guarantee and letter of credit is effective from 7th day of receipt of goods at Ahmedabad. Means the purchaser has a 7 day to sell it and give and credit his account. After 7 days, bank guarantee or letter of credit would be encased by the seller. One another condition was that since it is a raw cotton and perishable by moisture or water, shipment should not be changed in between. From USA to India, it should be shipped in a single ship, in a single container. Container is not to be changed. Ship is not to be changed. This is the condition. Now what happened? Goods doesn't received to India on a given date. Thereafter, on third or fourth day, suit was filed that only 4 days are left. If goods is not received on a given date, that date has gone. Now, if we didn't receive the goods in these 4 days, our bank guarantee or our letter of credit would be encased. We would be without goods and our money will go. Suit was filed. Only 4 days were there. I have issued notice through email. You will surprised to note it. An Advocate General of Madras High Court has appeared for an American company in Ahmedabad, traveling from Chennai to Ahmedabad overnight. Because my notice returnable was just 1 day after, because on 4th day bank guarantee is to be encased, and I don't want to give ex parte order because Supreme Court judgment is there, because American company is there. I don't want to make us so that we are doing something wrong. So notice returnable on day after tomorrow. Advocate General of Chennai High Court has appeared before me in City Civil Court. Now this is the background. Now real story comes. He radically came with a reply and everything that this suit is not maintainable and this and that, and email. See, there were number of emails. Emails are to be referred from not from by date but time, because within couple of days there were 100 emails. Now the interesting story is that when date for receiving the goods was passed, the Ahmedabad company has written just before a couple of days, Ahmedabad company has written an email to the American company that there is no confirmation about shipment. If you have not shipped the goods, we would like to check it. We are coming to USA. American company said, no. There is no condition to check the goods prior to shipment. Goods are already shipped. Ahmedabad company has asked for what you can say that container numbers. American company has sent container numbers. Ahmedabad company has checked those container numbers on internet and found that it was not shipped. It was not. Next, immediately email that these numbers are does not tally. They said that, oh, we have mistaken in typing. They send another numbers. Those another numbers were lying at Dubai airport for last 7 days. Means transshipment was there. Means once it was brought from USA to Dubai, lying in Dubai for 7 days. Now it is to be transported to Mumbai. Knowing this fact, on third day, I have asked the Advocate General of Chennai High Court that I don't want this 50-page reply. I want only one line on affidavit that this printout of emails submitted by plaintiffs are not sent by you. Means these emails are not proper. He said, yes, I will file immediately. I said, Mr. Be careful. These printouts are having a footnote disclosing the root of email that from which server these emails have received by the plaintiff. Ask your client before filing any affidavit, because in 2000 the Advocate General of Madras High Court, who was, with due respect, who was Advocate General or his colleague, his aged person, he was under impression that filing an affidavit that these printouts are not proper is very easy. He immediately contacted their client and they refused to file an affidavit on oath. What? That these emails, printout of these emails are not sent for them. They don't want, because those emails are having a footnote which discloses a typical code, which code, when cyber expert or when somebody verify it will give an idea or an address that from which machine, from which PC, laptop, iPad or phone this email has been generated. So if it is generated from particular machine, particular company's email ID, then you can't refuse that this email is not sent by us. And few of those emails were certainly creating a doubt, because numbers were wrong, transshipment was done, goods were not shipped from USA in time, it was not reached to Ahmedabad in time. Therefore, I confirmed the stay on 4th day. Matter was dragged to High Court, but High Court could not change it. Ultimately, they have settled the dispute and suit was withdrawn. So what is the bottom line is that how to prove digital evidence. As Rajiv has asked that advocates are not, therefore I think this is a good example, because this was before 21 years. So I will reverse it. Anybody of you has any question about digital evidence?
I had one small.
Pardon?
Sir, I had one small question.
Yeah.
Yes, in the current case, we try to say that to prove the evidence, we had actually gotten the phones and the laptops before the trial court to prove the correctness of the evidence without certificate under section 65B. Sir, will that be okay, and will that be considered as primary evidence if we get the instrument itself to the court?
No, instrument is not always required to be taken to the court. Instruments like tape recorder, and that is a different thing. But so far as this digital media is concerned, it is through software. Therefore, I have said that there is no primary evidence at all. Everything is in digital form. But then, to confirm, you must be aware about digital signature. To confirm that particular document is written by X and it is not altered in between, there may be digital signature. But so far as transferring some communication is there, physical machines are not required. IP address is enough. That it is generated by particular IP address and ownership of that IP address.
Okay, thank you.
Yes, and what else? What remains now?
Does anybody has any more questions that sir could address?
Sir, if there are no more questions, we can conclude and have the break, and you can decide with the marking.
Sure.
Before that, Kanchan, if you can just conclude, please.
Yeah, sure. Thank you, Sir Justice Subodh Kumar Shah, for your valuable feedback and your insights. I also extend my gratitude to our mentors for their comments, our participants for their hard work, and the guests watching us on YouTube for their patience. It was truly a delight to have attended the competition and listen to the pleadings of both the sides. I personally got to learn a lot. Sir, we would especially like to thank you for your active participation. We'll be taking a short break now. Sir will be scoring the teams and finalizing the winners. We shall begin the award ceremony at 6 p.m. sharp. So everyone is requested to please join in at 5:50 p.m.
Okay, thank you.
Thank you so much, sir.
Thank you, sir.
Thank you so
Thank
much.
you,
Sir.
thank you,
Thank
sir.
you so much, sir.
Thank you.
Thank you so much, sir.
Thank you.
Thank you so much.
Thank you, sir.
Thank you. So now
Sir, we can call you. Rahul and I will call you.
yeah, exactly. After Rahul and Gaurav are available, call me.
Yes, sir. Like you can take 5-10 minutes for your scoring, and after that we'll call you, sir.
Okay. Thank you.
Thank you, sir.
Thank you.
The participants are allowed to leave the meeting now.